Thank you, Mr. Chairman and committee members. I appreciate the opportunity to be heard on these very important pieces of legislation, S-2491 and S-2492. Both are products of a domestic violence bill which I sponsored last year. With regard to S-2491, Mr. Chairman, this bill describes who is illegal to possess a firearm. It makes a technical change to the law prohibiting any person subject to a domestic assault or domestic abuse restraining order or convicted of a domestic violence felony and serving community confinement from possessing a firearm. These changes would be consistent with the language in S-2490, which will be introduced by Senator Goodwin, should S-2490 be voted out of committee. Next, Senate Bill 2492, sir, does not create a new crime. Rather, it deals with existing domestic violence felonies as well as crimes of violence and removes firearms from those convicted of such felonies. To be clear, persons convicted of a felony, whether or not related to domestic violence, are currently prohibited from possessing a firearm under federal law. This legislation does not expand upon that, but our current law is silent as to the implementation of that federal prohibition. This bill provides the mechanism for surrender of firearms owned or possessed by the convicted felon and lays out a clear and concise process for doing so. This was a concern of the Second Amendment advocates last year and now has been addressed in this bill. Additionally, the Police Officers Commission on Standards and Training will be required to establish policies for the return and disposal of surrendered firearms so that all law enforcement agencies throughout the state are adhering to the same procedures. This, too, was a concern of the Second Amendment advocates last year and now has been addressed in this bill. Finally, this bill allows the defendant, within 60 days of their firearm surrender, to petition the court to transfer that surrendered weapon to an eligible third party. A person is considered an eligible third party if the court finds, after hearing, that there is no legal prohibition against the transferee possessing a firearm, and most importantly, that that transfer would not endanger the victim of the offense which prompted the need for that surrender. This procedure responds to the due process concerns raised by some gun owners and those representing them at last year's hearing, while providing a critical safeguard to protect the victims of domestic violence. Mr. Chairman and members of the committee, you have heard the alarming statistics involving crimes of domestic violence and firearms. They are a lethal mix. These bills have been mislabeled by some as anti-gun legislation. They are not. They are intended to provide protection to the victims of domestic violence while protecting the due process rights of gun owners. Over the course of last summer and fall, I reviewed the testimony of last year's hearings in close detail to formulate this legislation. I have consulted with the Department of Attorney General and have met with numerous stakeholders, including representatives from the Rhode Island Coalition Against Domestic Violence, the Rhode Island Coalition Against Gun Violence, Moms Demand Action, and the Rhode Island Police Chiefs Association. As recently as yesterday, I met with Mr. Sikosha representing the Rhode Island Second Amendment Coalition. Some may still say this legislation does not go far enough, yet others may still say it goes too far. Mr. Chairman, we have a bill that I believe works for all the stakeholders while remaining true to the intent of this legislation, which is to protect the victims of domestic violence. Simply put, Mr. Chairman, if you own a gun and do not engage in domestic violence, neither of these bills will affect you.